In this episode, we talk about the factors that the courts look at when choosing to impose the death penalty. We also talk about the recent findings at a famous Buddhist archaeological site in Odisha. But first, we talk about Donald Trump's executive orders. Hi, I'm Shashank Bhargava, and you're listening to Three Things, the Indian Express news show. On his first day as the 47th President of the United States, Trump issued a series of executive orders that captured global attention. For example, he signed orders to withdraw from the World Health Organization and the 2015 Paris Agreement. He also mandated that the United States would officially recognize only two genders, male and female. Now, in the coming days, we will discuss these orders in detail. But today, we focus on another executive order he signed on Tuesday, the one concerning birthright citizenship. Through this order, Trump has proposed revoking automatic citizenship for children born in the US to non-citizen parents.
This next order relates to the definition of birthright citizenship under the 14th Amendment of the United States.
That's a good one. Birthright. That's a big one. It's ridiculous. We're the only country in the world that does this with birthright, as you know. And it's just absolutely ridiculous. But, we'll see. We have very good grounds.
Sir,
People have wanted to do this for decades.
Sir, this is a
Now,
proclamation.
just to clarify, the US is not the only country to offer birthright citizenship. There are, in fact, about 36 countries that do so, including Canada, Jamaica, Peru, and Argentina. But to discuss the US's decision and how it will impact Indians living in the country, the Indian Express's Divya A joins us.
So as soon as Donald Trump's inauguration happened on the 21st, there were a slew of executive orders that he signed, and most of them were really radical. One of the first orders, which is listed on the White House website, that pertains to birthright citizenship, and the Donald Trump regime, they aim to revoke that. So anybody who is born by virtue of being born in the US won't be a citizen anymore. And this order apparently comes into effect in about 30 days. So that is a very, very big significant change. And it is going to impact a lot of Indian people who are in the US on temporary visas, like those on H-1B, the student visas, those who are on spouse visas. So anybody who's not a citizenship and gives birth to a child, that child doesn't become a citizen of the US naturally. So that's what we're talking about here.
And Divya, you spoke about how this might impact a lot of H-1B visa holders, for example. And for those who might not know, these are basically immigrant workers in the US in occupations that require, quote unquote, a high level of skill and at least a bachelor's degree. But can you focus on how it will specifically impact the Indian community?
Yes. As of 2024, it is estimated that there are about 5.4 million Indian Americans in the US, out of which about 2/3 are immigrants who have got the citizenship, in some form, and 1/3 are birthright citizens who got US citizenship by virtue of being born there. So every year we see a lot of Indians on student visa in the US, Indians on any kind of temporary work visas, even the H-1B. 70% of H-1B, beneficiaries are Indians, as we know. So all of them, if they have a child in the US, that child doesn't become a citizen of US. So that is going to be largely affected. And birth citizenship was also a way of immigrant parents to make sure that the child is with them, the child remains in the US, and the family sticks together. So a lot of things are going to be affected in the days to come. Of course, there is no retrospective implementation. So whatever has happened before January 21 doesn't change. But we see when it comes into effect, as and when it comes into effect, or if it comes into effect, it'll be a lot of chaos for Indian American community and Indian families who are there on different kind of visa statuses or residence statuses.
And also when it comes to students, a lot of people from India go to the US to study. Will this decision give them second thoughts? And if that's the case, maybe you can also elaborate on why that will be the case.
So there's a lot of cases. It's a trend that students, when they turn 21, and if they have the birthright citizenship, if you have been a US student and have a birthright citizenship, then you also call your parents, because your parents can come on your dependent visa. So if the student is not a citizen anymore after turning 21, he or she cannot call the parents. So it'll, in a sense, disintegrate families. So people are having second thoughts about a lot of things, because getting a US citizenship just by being born there was a big bank that, the Indian American community was, depending on. So now if that is taken away, there would be second thoughts for sure. Also, there is also a trend of birth tourism that, women close to delivering a child, they go to the US on like any kind of temporary visa, dependent visa, spouse visa, tourist visa even. And when the child is born there, the child gets citizenship. So now that will also be affected. So a lot of uncertain thought about the future will come into play, and we have to see how it pans out in the days to come.
And we know that some of the other decisions, like the one about WHO and the Paris Agreement, were expected in a way. But did this come as a surprise to people?
Totally. There was a lot of talk about illegal immigration, undocumented people from all countries who are in the US, they will be deported and the borders will be strengthened. We have been hearing about this. So there was expectation that there will be some radical landmark orders regarding deporting undocumented migrants, or there was a narrative about H-1B being affected, how H-1B workers are taking up the jobs that Americans should have got. So there was that also happening. So all of that was expected, that there would be some changes which pertain to H-1B or which pertain to, undocumented citizens. But there was, no word about birthright citizenship being revoked. But with Trump, as they say, unpredictability is the only thing you can predict. So in 2018, in one of the interviews, he had called this ridiculous. But in this campaign, there wasn't much talk about it. No.
Yeah, and we have to see, like you said, whether this will be implemented. There is a shadow of illegality to all of this, because birthright citizenship is part of the 14th Amendment of the US Constitution. So could you talk about that a bit and what legal experts have to say about it?
See, legal experts say that birthright citizenship arises from the US American Constitution's 14th Amendment, which was ratified in 1868. So an executive order like this would face immediate legal challenges, and there's a likelihood that it would be struck down by the courts, and amending the Constitution may be the only sure shot way of taking it forward, and that we know is a long, tedious process. So we have to see how and when it really comes into effect. As of now, they have said 30 days. See, the 14th Amendment of the Constitution is also based on interpretation. So while one side is interpreting that, it says that birthright citizenship is guaranteed to anybody who's born in the US, despite both his parents or one of his parents being of any status. But the Trump side tries to interpret it in different way. They are saying that that is not what the 14th Amendment meant, and it means that it is only guaranteed to those who are part of the subject to the US jurisdiction, and they define the jurisdiction in their own way. So I think it will now be based on how jurisdiction is defined, and the Trump administration, as they have put out on the White House website, they say that when that person's mother was unlawfully present in the US and the father was not a US citizen, then that is not jurisdiction. Or when the father was not a permanent lawful resident at the time of the said person's birth. So essentially one of the parent has to be a US citizen and not like a temporary visa or any temporary resident status holder, which could be H-1B or anything.
And next we talk about the death penalty. On Monday, a Sessions Court in Kolkata sentenced Sanjay Roy, convicted of the rape and murder of a doctor at the Archaeological Medical College, to life imprisonment. The verdict came as a disappointment to many, including the CBI, West Bengal Chief Minister Mamata Banerjee, and the doctors at the hospital who had led the protests in the city demanding the death penalty in the case. Now, while delivering the verdict, Additional District and Sessions Judge Anirban Das explained that he chose not to impose the death penalty because he did not consider it a rarest of rare case. This distinction is significant because the Supreme Court mandates that a sentence of death should only be passed in the rarest of rare cases after the court has considered possible aggravating and mitigating circumstances. To understand these distinctions in detail, we are joined by the Indian Express's Ajoy Sinha Karpuram. Ajoy, what does the court mean when it says rarest of rare cases? What counts as a rarest of rare case?
So the court laid down this benchmark in a case called Bachchan Singh versus the state of Punjab. The case stemmed from an incident where a man, Bachchan Singh, murdered 3 members of his family, and he had already served a life sentence previously for the murder of his wife. The case reached the Supreme Court because Bachchan Singh's lawyers had challenged the constitutionality of the death penalty. They said it was a cruel punishment that violated the right to life with dignity and was arbitrary and served no real purpose. However, the court upheld the death penalty for several reasons, saying that it does serve a purpose, stating that it serves as a deterrent for such future crimes, among many other reasons. However, it wasn't a unanimous verdict. It was a 5-judge bench and 4 judges were in favor of retaining the death penalty. However, Justice P.N. Bhagwati wrote a rather prescient dissent, which has become more and more relevant as the years go on.
Okay, so the Supreme Court is saying that the death penalty can act as a deterrent, for example. But what sort of guidelines has it laid down for how courts can decide which cases would qualify for the death penalty?
So the basic standard that the court laid down in this case was the rarest of rare standards, essentially saying that the death penalty should only be imposed in cases where there is no possibility of reformation and no possibility of rehabilitation on the part of the accused. And it also accepted and put its weight behind the argument of Dr. Chitale, one of the advocates in the case, who had put forth certain aggravating and mitigating circumstances that could possibly be considered to see if a case falls into this realm, to see if a case falls into this rarest of rare category. The court also made it very clear that these were not an exhaustive list of aggravating mitigating circumstances. This is a list that can be built on by future cases and future judges, depending on the circumstances of each case that comes before them. Some of the circumstances that the court did acknowledge were in the realm of aggravating circumstances, for instance, whether the crime itself was premeditated or pre-planned.
And these are the circumstances that would tilt the case in the favor of the death penalty.
Yes, absolutely. And which includes whether the crime was planned beforehand. For example, if it's a murder, whether it involves exceptional depravity. And also depending on who the victim of the crime was. For example, if the victim was a public servant or a police officer or a member of the armed forces, this would also be an aggravating circumstance. But then when we come to the realm of mitigating circumstances, which is arguably the more important limb of the Supreme Court's judgment, the Supreme Court said that mitigating circumstances need to be given a liberal and wide, expansive interpretation. If there's a relevant argument for something to be a mitigating circumstance, it has to be considered. These include the age of the accused, and that could be whether the accused is very young or very old. It could be what the mental state of the accused was at the time. The exact words used by the court were whether the accused was under the influence of extreme mental or emotional disturbance, whether the accused would pose a future threat to society if she is released, or what is the possibility of this accused being reformed while they're in jail. And these mitigating circumstances have been expanded by the courts in later years.
And Ajoy, when we look at these mitigating and aggravating circumstances, some of the things mentioned can have a very subjective interpretation, right? For example, what counts as an exceptional depravity, or whether the person convicted in the case can be reformed or not. So does the court account for that?
So the short answer to your question is that courts have tried, but so far they haven't quite succeeded to make this less of a subjective exercise. This is a problem that Justice Bhagwati predicted to a certain extent in his dissent. He said that these interpretations would inevitably become subjective and would be based on the individual views of the judge involved in that case. And this is an issue that was echoed by the Law Commission in 2015 in its 262nd report, where it looked at various factors such as how courts have considered the age of the accused and how courts have considered the nature of the offense and the possibility of reform, as you mentioned, and found that there wasn't a golden standard that courts have been following in all of these cases. In some cases where the accused persons are below the age of 30 and they are too young to be given the death penalty. In other cases, this hasn't become a consideration. It was either rejected as a consideration or just wasn't considered in the judgment at all. Similarly, when we're talking about the nature of the offense, some judges have held the rape and murder of a young child to be an extremely heinous case and therefore deserving of the death penalty, whereas other judges haven't ruled as such and have only granted life imprisonment in such cases. And while there are some cases that have attempted to put down an objective standard, for instance, the Supreme Court has directed that in cases where the court is considering the nature of the offense, it should look at a pool of cases involving similar offenses and look at the punishments that have been meted out in those cases and judge it based on that. But considering the vast scope of cases that we have and considering the sort of the asymmetry that we were just discussing, that in itself may not be the most helpful of directions. And other cases have arguably only added to the murkiness. For example, in Machi Singh versus State of Punjab, the Supreme Court held that the death penalty could be awarded in cases where the collective conscience of society was so shocked that the judiciary was expected to impose the death penalty. And with that, the necessary question comes from that is, are we allowing public opinion in these cases then to sway the court one way or another on whether the death penalty is deserved? And as I said, Justice Bhagwati sort of predicted that these kinds of problems would crop up and that this subjectiveness would be the undoing of the ruling in Bachchan Singh and of the standard laid down in Bachchan Singh.
Right. And after the Bachchan Singh case, the courts were mandated to conduct a separate trial for the death penalty after the person was convicted. And these trials, of course, can happen on the same day as well. But when it comes to this matter, the Supreme Court has also stressed on the importance of a real, effective and meaningful hearing and has said that the state has to conduct an investigation into these mitigating circumstances. Now, is all this being done because we are giving the death penalty that seriousness? Because, in some sense, this is the ultimate order and you want to make sure that, one, you're making the right decision, and also because you want this to be the last option.
Absolutely. And the courts have made several rulings to treat the death penalty with the gravity that it deserves and make sure that these accused persons or these convicts in several cases get their day in court. To the point where, for example, a review petition in the Supreme Court. A review petition is essentially where a petitioner says there was a mistake in one of your judgments. If there was a mistake on the face of the record in one of your judgments, and because of that, the judgment is erroneous. Please reconsider this case. Usually when the court hears these review petitions, it does so in chambers. These are not public hearings. The written arguments are just submitted to the bench and they consider them. And if it's rejected, they will simply write a verdict saying the review petition has been rejected. And if it is accepted, they will give a verdict with reasons. In death penalty cases, the Supreme Court has held that these review petition hearings have to take place in open court and the accused must get their day in court. And there are several other rulings like this to make sure that the death penalty is never wrongly imposed on someone. But what that also does is it extends the trial to sometimes a ridiculous degree. And throughout that trial, this person, this accused, is sitting on death row waiting for a verdict. And that, studies have shown, has an immense impact on their mental health. And because of that, an immense impact on their physical health as well.
And in the end, we talk about Ratnagiri, the famous Buddhist archaeological site in Odisha's Jajpur district. Last month, a team of Archaeological Survey of India, after a gap of 60 years, took up excavations at the Buddhist complex in Ratnagiri. The idea was to uncover more of the complex and find material evidence of the state's link to the larger Southeast Asian culture. Now, since the excavations began, the team has already found a colossal Buddha head, a massive palm, an ancient wall, and inscribed Buddhist relics, all of which are estimated to date back to the 8th and 9th century AD. To discuss the significance of these findings, we speak to the Indian Express's Sujit Bisoyi. Sujit, for those who might not already know about it, can you give a sense of how significant a site Ratnagiri is?
Shashank, Ratnagiri is part of very rich Buddhist heritage site in Odisha and called Diamond Triangle. The three Ratnagiri, Lalitgiri and Udayagiri. These three hills located at a very close proximate within 20-kilometer radius. They form Golden Triangle and known to be one of the rich Buddhist learning sites in the ancient past. And excavations were carried out so far as tremendous Buddhist architectures. And if we'll talk about Ratnagiri, and that is called the Hill of Jewels in translation. So this is known as one of the most well excavated and most explored ancient Buddhist heritage site. Its first historical record was made in 1905 by a then British bureaucrat. Then post-independence, between 1958 to 61, one senior archaeologist called Devala Mitra, who became the DG of ASI in the later stage, she made some efforts to take up the excavation work and found some tremendous Buddhist architectures. Then that was stopped for some years because of ASI's focus on the other Buddhist heritage site in the nearby area. Now, after 6 decades, ASI's Puri Circle, they have again taken up the excavation works recently, starting last December, December 2024.
Yeah, and the team that is conducting excavations there is being headed by the local superintending archaeologist D.B. Garnayak. And so far they have uncovered, like we mentioned, a colossal Buddha head, which is about 3 to 4 feet tall. And they have also found an ancient wall and other relics. Can you talk about how big of a deal that is?
So, when we tried to explore more on this and to file a story on this, I spoke to one renowned Buddhist researcher. So, according to him, the size of Buddha head and the palm and other things, head is only 5 feet tall and Buddhist palm is only 3 to 4 feet height. So, you can imagine the size of a total Buddha statue. So the excavation is still on and that will continue for 1 to 2 months. So they are hoping to find more actually. So according to Sunil Patnaik, the researcher who is the secretary of Odisha Institute of Maritime and Southeast Asian Studies. So he said this shows the richness of Buddhist architecture in that place. That is the significance basically.
Right, and these excavations are still going on. But the other thing is that this excavation was taken up after 60 years. Could you talk about what was the reason behind that?
So I spoke to Garnayak, who is the superintending archaeologist of ASI's Puri Circle. So he said the latest excavation aims basically to unearth the partially visible structure because Ratnagiri is a known Buddhist heritage site. They know a lot of Buddhist architecture are beneath, but because ASI has identified a lot of partially visible structures and sculptures there. So that is one purpose, and their effort is also to find out if any shrine complex or Chaitya complex, that is a sacred Buddhist assembly or prayer hall, what we call. So during the 58 6-decade back excavation, they have already excavated one Buddhist prayer hall. So now they are trying to find out whether there are more such prayer halls as noticed in neighboring sites. And the purpose of the excavation is also to know the ceramic assemblies, that is a collection of pottery found at an archaeological site. And one more aspect, because Odisha has that ancient name is Kalinga and is known to have a very rich maritime past we have in Odisha with Southeast Asian region. So the purpose is also to study to find evidence on the material culture. So material culture, if I'll explain, is the aspect of culture studied through physical object and architecture. And it is to find out the evidence on Southeast Asian origin or beyond, and to understand the cultural framework of the colossal Buddha, because there are some technical things like the Buddha head which they excavated recently has different hairstyle from the Buddhas in other part of the world. So they want to study more on this actually. So this is what the SI has to say now.
And you were talking about Kalinga earlier. Can you talk about that aspect a bit more and talk about how the origins of Buddhism seem to be connected to this region?
though there is no historical evidence, documental evidence, but it is called that Mauryan Emperor Ashoka the Great is believed to have invaded Kalinga in 261 BC. And there are talks that he deeply moved by the bloodshed in the war, which is 261 BC, it is Kalinga war. So he deeply moved by the bloodshed in the war, and he eventually embraced Buddhism. And not only that, he even started spreading Buddhism in this region, because Kalinga is known to have trade links with Southeast Asia, countries called Java, Sumatra, Burma, which is today's Myanmar, and Ceylon, that is called Sri Lanka. So we had historical maritime links. So this Ashoka started spreading Buddhism to these parts also.
You were listening to 3 Things by the Indian Express. Today's show was written and produced by me, Shashank Bhargava, and was edited and mixed by Suresh Pawar. If you like the show, then do subscribe to us wherever you get your podcasts. You can also recommend the show to someone you think will like it. Share it with a friend or someone in your family. It's the best way for people to get to know about us. You can tweet us at Express Podcasts and write to us at podcasts@indianexpress.com.